This is Duke University.
At the law school, it is my pleasure to introduce and to bring to you Marc Elias, who's a Duke alum, and he's going to talk to us about Recounts and Bush v. Gore. He was earlier talking in my class, and so we were joking about this, but he is the leading election law lawyer in this country, with a focus on campaign finance, government ethics. He represents a vast majority of the leading politicos on the Democratic side in this country, and it's really been a pleasure hanging out with him these last couple of days, and to have him come and talk to you about recounts and elections. Marc and I talked about this last night. If there was an election law practice when I graduated from law school, I probably wouldn't be an academic. I'd probably try to do what it is that Marc here has been doing for these past 13 or 14 years. So it's my distinctive pleasure to welcome him back to his alma mater and to have him talk to us about elections and recounts. Please welcome Marc Elias. Marc.
Thanks. Thank you. Well, it's a pleasure and honor to be back at Duke. The law school has changed significantly for the better since I was a student here. And what I wanted to do was talk a little bit about where post-election disputes have been, where they are and where they're going in the legal system, and then sort of take questions and answers or take questions as people have them. So we have just passed the 10-year anniversary of Bush versus Gore, which, as you know, was the Supreme Court case that stemmed out of the 2000 presidential election. And when Professor Charles asked me what it is I'd want to talk about here, I talk on a lot of subjects. I talk most often on campaign finance and Citizens United and what's happening to the campaign finance system. I do a fair amount of talking about governmental ethics and sort of how those are being shaped and what are various things that the Obama administration have put in place. What have they meant in terms of transparency and the like. And this, with the redistricting process underway, I do a fair amount of talking on redistricting. But when I was asked what I wanted to address today, I thought, if I were a law student, what would I find most interesting? And then I said, okay, well, I'm not going to talk about that. What else would I find it maybe less interesting, but somewhat interesting? And I thought it's a really good opportunity to look back and ask kind of how do we go about in this country resolving election disputes, and what is the role of sort of the law in this process going forward? So the way I wanted to start is to think of Bush versus Gore as three things, okay, which is not always captured in the textbooks and in law school classes. Bush versus Gore is a case, okay, and for those of you who will read it in election law class or a con law class or anything else, for you, it'll be a case. It'll be something that is where the justices have recited a set of facts, have gone over a series of legal principles that they have applied to that facts, and then come to a conclusion. And it's the way in which we teach law. It's the way in which we learn law. So it's unavoidable. But the problem with understanding Bush versus Gore that way, which is the dominant way in which people think of Bush versus Gore. When I did a conference in Ohio State on Friday, Ohio State Law School, where I was the keynote speaker during a conference on what alternative dispute resolution mechanisms might offer post-election disputes. Okay, is there a way that we can deal with post-election disputes through mediation or arbitration or other kinds of non-judicial alternative dispute resolutions? And there was a lot of talk in the room about Bush versus Gore. I mean, a lot. The law professors who were the predominant folks on this symposium talked a lot about Bush versus Gore. When I did my little lunchtime chat, me and Ben Ginsberg, who's a Republican lawyer in Washington, D.C., we oftentimes get invited to these symposiums so that when the academics are eating, we get to entertain them. So this was an opportunity for us to do our entertaining. And you know, I said to them, as I'll say to you, we have reduced Bush versus Gore into what most legal disputes get reduced to, which is a case, right? Bush versus Gore started as an election, right? Started as an election in 50 states with thousands and thousands of workers, with television ads, with get out the vote programs, with ballot access disputes. And then it reduced itself down to a post-election dispute. But it is mostly known as a case. The second way to think of Bush versus Gore, though, is as a fuller election dispute, which before you get to the case, right, that decision that everyone focuses on and either thinks it was rightly decided or wrongly decided, or the conservative justices were being partisan, or the liberal justices were being partisan, or nobody was being partisan, or everybody was being partisan. Before you get to any of that, there is a series of cases, a series of disputes, a series of court hearings, a series of legal decisions that have to be made about, do we challenge this? Do we challenge that? Do we file in state court? Do we file in federal court? Do we have different plaintiffs and try and split claims? Do we pursue certain kinds of claims or other kinds of claims? So Bush versus Gore is also an election dispute that involved many facets. And then finally, Bush versus Gore is a principle. And I think in the vernacular, like when non-law students or academics think of Bush versus Gore, they sum it up as follows. Bush versus Gore stands for the proposition that equal protection principles require that there be standards set in order to count ballots, right? So Bush versus Gore, in sort of a more general sense, when you say to people, oh, well, that fact pattern implicates Bush versus Gore, they're really talking about a principle, right? They're talking about the application of equal protection principles principally to the counting of ballots, but sometimes more broadly to election disputes. And I want to talk about each of these three things and how we got there and what's happened since then. And the place I want to start is with a case from the 11th Circuit in 1995 called Roe versus Alabama. If you read the papers of Bush versus Gore, the actual legal pleadings, you'll see that the concept of this case being an equal protection case sort of was secondary. One of the primary arguments that they were advancing was a due process argument, and that was that there is a due process right to certainty in the rules, to articulated rules, and then to have those rules followed. So Roe versus Alabama involved a judicial election, I believe for state Supreme Court, in which there were absentee ballots cast. And the absentee ballots that were, when the election was over, it was a very close election. It turns out there were a bunch of absentee ballots that had been cast by voters where the witnessing requirement had not been fulfilled. Alabama, like a lot of states at that time, required that when you cast a ballot absentee, you have a witness that you are the person you say you are. And they had to sign an affidavit saying, I watched that person cast their absentee ballot, and they're the ones who cast it, and they sealed it, and that affidavit would get then submitted along with the absentee ballot envelope. And there were a series of ballots that were cast that had incomplete or not properly completed affidavits. And the state court that heard this election dispute said, you know what, it's true. They didn't fill out this affidavit form. But we have no reason to believe that there was any fraud. We have no reason to believe these voters weren't lawful voters in Alabama. So we're going to go ahead and count them. And the folks on the other side wound up going to federal court, and the case goes up to the 11th Circuit. And the 11th Circuit says, no, can't do that. That once a state has articulated rules and those rules have been followed in the past, there is a reliance interest that both voters and non-voters, right? Because think about it. Let's say you're from Alabama and you're sitting in Durham, North Carolina, casting your absentee ballot, and you need a witness. You need another Alabaman to witness your ballot as an affidavit. And you're sitting there thinking, I don't have a witness, right? So you could do one of two things. You could either say, well, let me send it in anyway. Or you could say, you know what, I'm a law student. Let me go look online and see whether or not I can do this without a witness. And lo and behold, you discover that you need a witness. And then, in fact, in the past, courts have enforced this witness requirement. And what the court in Roe versus Alabama was saying is that not only is there a reliance interest by the person who cast the ballot right, but the non-voter, the person who says, well, geez, and I can't vote absentee. And I guess I can't vote. Because if I submit it without an affidavit filled out by a witness, it's not going to count. So therefore, I won't vote. And that your interest is harmed if another person who was not as diligent cast the ballot and had it counted. So you have this tension between counting everyone's vote and requiring, and due process principles requiring everyone follow the same rules. That case was out there, and there were a handful of other cases like they're out there before Bush versus Gore, and Bush versus Gore comes along. And the question that comes before the Supreme Court is, what do you do where you have a hand recount where there are either no standards for how you judge one hanging chad or two hanging chads, right? Like, how do you know if it's really a vote for Bush or really a vote for Gore? And it's particularly exacerbated by the fact that you have different counties judging these things. And if there's no articulated standards, they could use different standards from county to county. And the Supreme Court, as we know, halted a statewide recount and said that equal protection principles require that there be uniform standards before a recount can go forward. That's Bush versus Gore. So where does that kind of lead us to? It leads us to a series of recounts that have taken place since then, and post-election disputes that have taken place since then. But before I talk about some of those, Bush versus Gore, that's Bush versus Gore, the case. Bush versus Gore, the dispute, changed, in my view, fundamentally the psychology that Americans have about elections, and fundamentally the psychology that we have about post-elections. Until Bush versus Gore, it was, I think, widely understood that elections are political, which they are. They're partisan, which they are. And therefore, who makes decisions in a given campaign about decisions? You have a candidate, you have a campaign manager. Before Bush versus Gore, post-elections were viewed as part of that political process. So they were largely driven by the same sets of consultants and decision makers that would be available to the campaign. And indeed, if you look at Bush versus Gore, ask yourself, who did George Bush and Al Gore put in charge of their recounts? Former secretaries of state, right? You've got James Baker, who is a very prominent individual, very, very skilled, but I doubt he's ever done a recount. Right? He's not a recount expert. And you have Warren Christopher. And that's because I think fundamentally up until that point, these were still being viewed through the prism of politics. These were still, we're going to have a dispute. We'll have an esteemed person like James Baker, and they will make sure that fairness takes place and that partisan interests are protected and do all of those things that go on. And though lawyers wind up coming to the forefront of Bush versus Gore when it gets before the Supreme Court, obviously because they argued it for the Supreme Court, Bush versus Gore really marked the key moment in which these disputes change in character from largely political, predominantly political, with lawyers supporting a political objective, to largely legal. They're still political. I mean, still have political consequences, obviously, and they still have political actors involved. But where, after Bush versus Gore, the idea that there will be court involvement in a post-election dispute goes from being an anomaly to an expectation. So, I don't know how many of you remember this, but certainly Professor Charles would. On the eve of the Bush versus Gore court cases, everybody you asked who was a lawyer would tell you the Supreme Court will never take the case. The Supreme Court's never going to take this case. The courts are going to want nothing to do with this, right? That's the language in which we thought about recounts and post-election disputes before Bush versus Gore, right? These are political things that courts are just not going to want to wade into. And in fact, the case Roe versus Alabama was very controversial in that you had a court weighing into it, and it's why it stands out all by its lonesome there. In 1998, just to give you some sense of this, in 1996, I was a consultant to the Senate Rules Committee over the disputed Senate election in Louisiana between Mary Landrieu, who won the election and was seated as a senator and remains a senator, and the person who ran against her named Woody Jenkins. When Woody Jenkins lost that election, you know what he did? He filed a petition to the U.S. Senate. I mean, forget about the courts, right? Why would you go to the courts? We'll go to the Senate. Because this is fundamentally a political question. This is a question of who the Senate is going to seat, whether they think I really won or they think the other person really won. So the Senate Rules Committee hired lawyers who worked for the Senate Rules Committee to determine the outcome of that election. That was not a common practice. I don't want to overstate it, but it was not an unheard of practice. The idea that the House itself or the Senate would engage in those practices it had done over the years because of this dichotomy. Bush versus Gore, I think, really changed that. And in fact, it's funny because in Minnesota, I was the lead recount lawyer for Al Franken in the 2008 Senate recount and contest. And at one point, I held a press conference. One of the myriad jobs that I had was I was also the chief spokesperson for the effort. So I did press conferences almost every day during the recount. And at one point, I suggested that, you know, if certain category of ballots were not seen fit to be counted by the state of Minnesota, we might very well bring it to the U.S. Senate and let the U.S. Senate count them. And this was greeted with outrage by the other side. I mean, the Republicans thought this was the most outrageous thing they'd ever heard, and the media was pretty hostile to it. So it was interesting. Between what Bush versus Gore did was it reset expectations that these processes are going to be fairly handled. If before Bush versus Gore, people thought they were fairly handled in the political process and the courts would stay out because it was too political, following Bush versus Gore, there is an expectation that the only fair way these to be handled is through the legal process and through the courts. And that has had some consequences. So let me talk a little bit about Franken. Al Franken ran against Norm Coleman in 2008 for senator from Minnesota. On election night, Franken was trailing by 725 votes. There was then a canvass of the votes, which is like a retabulation. The counties all go home, they get a good night's sleep, they come back, they see what errors they made, and Coleman's lead dropped to just over 200 votes. So at the end of the certified results, Norm Coleman, or the pre-recount certified results, Norm Coleman was winning by just over 200 votes. And to understand Franken, like to understand Bush versus Gore, you need to, again, unpack those three things. There is the case that is Franken. If you all go and you Google or Nexus or go on Westlaw and you look it up, what you'll come up with is in re contest of general election held on November 4th, 2008 for the purpose of electing a U.S. senator from the state of Minnesota. Okay, that is the court case. But to understand the import of it, or how that case wound up being the case. As with Bush versus Gore, you need to understand the dozens of other decisions behind it. So we in Minnesota went to the state Supreme Court on 4 different occasions. We litigated 4 cases at the state Supreme Court. There were at least 3 other cases that were litigated at lower courts that didn't go to the state Supreme Court. And each one of those cases wound up being a building block that when you read the excerpted in a case book, Coleman v. Franken, you don't see the building blocks. You don't see the building blocks behind them. So for example, the first piece of litigation in Minnesota was over whether ballots were being kept securely. The Republicans had brought a lawsuit claiming that certain ballots in Ramsey County, or I'm sorry, in Hennepin County had not been secured properly, and that therefore any ballots that were not properly secured couldn't be counted. Suffice to say, Hennepin County is Democratic. Minneapolis, where these precincts were that they were complaining about, are particularly Democratic, and had that lawsuit gone the other way, there never would have been the case in the book, in the case book. The next case that we litigated in Minnesota was it was a Public Records Act lawsuit. We had requested copies of rejected absentee ballots. Our view was that there were some number of Minnesotans who had cast absentee ballots that had been rejected by local counties. We didn't know how many. We knew that it was more than one. and less than 1 million. Okay, but there was some number, and ultimately we were able to define it down to some place between 1,000 and 2,000. But we knew there were some number of people who'd cast absentee ballots, had them rejected, where they were rejected by mistake. The counties had just made a mistake. In the rush of the election, they rejected ballots that should have otherwise been counted. Now, you can't prove that that's right. Okay, and that actually, when you read the final decision, most of the decision is about that issue, is what does it mean to cast a lawful ballot absentee in Minnesota, and under what standards does it get counted or not counted? But you don't get to that case, you don't get to the Supreme Court, you don't get any of that unless you're able to prove that the ballots were improperly rejected. Well, how do you prove that a ballot was improperly rejected? Well, you can't do it without knowing who cast the absentee ballot and that it was rejected. So the first thing we did was we filed the equivalent of FOIA, an open records request under state law, for copies or lists of people who had filled out their ballots, sent them in, and they had been rejected. Now, understand, we weren't looking to find out who they voted for, right? We weren't actually looking for the ballot. We were looking for the rejection. We were looking for, you cast a ballot and it didn't count. And then ultimately we were looking for the outer envelope, the security envelope, so that we could see your address, and there were some codes on it as to the reason why a county had rejected the ballot. And we went and filed those open record requests, and 87 counties told us no. There are 87 counties in Minnesota. They all told us no. So we sued Ramsey County, which is the seat of government. We figured we'd sue them, if need be, one at a time. We'd start with the seat of government and work from there. We sued Ramsey County in district court, in state district court, saying that we were entitled to these records. It wasn't a fancy lawsuit. There was no high principle of constitutional law. It was just your records law says that we're entitled to public records. These look like public records to us. Please give them to us, and here's why we need them and need them fast. And we won that. We won that court case. That case, again, never winds up moving beyond there, and therefore it sort of falls off the plate of things that people think about when they think about Coleman v. Franken. But it was just as important, and in some ways more important than any of the other litigation that followed. The big issues in Coleman versus Franken, the big issue in Coleman versus Franken, as I said, dealt with the question of individuals who had cast absentee ballots and had them rejected. Now, you have to understand this, you have to break it into little bite-sized pieces. Some people's ballots were rejected because they had already voted. So there are lots of good reasons why people have their absentee ballots rejected, right? In Minnesota, you can vote by mail, or you can vote absentee, and then if you're in state, you show up and you vote in person, so they throw away the absentee, okay? Some people had their absentee ballot rejected because they weren't registered to vote in the state, or because they didn't apply for the ballot. The number of people, surprisingly enough, who get an absentee ballot and then decide they don't need it, so they give it to their friend. Right? Those people's ballots were properly rejected. Then there were some number of people whose ballots were improperly rejected. There was one county that had put on the code next to reason for rejection. They had checked other, and then next to the little line for other, they wrote, "We messed up." So reason for rejection of their ballot was, "We messed up." There was actually some counties that had an election rejection code called election judge error, right? Which meant we messed up, just in more formal language. So there were, over time, through a number of processes, a number of these ballots got counted. And ultimately, I should point out, Franken's lead, strangely enough, existed irrespective of the absentee ballots. At the end of the hand recount, the Coleman's lead had flipped from up just over 200 votes to down 41. So Franken, actually, without any of the additional absentee ballots, would have won the election, and has been pointed out to me since I was the architect of the plan to chase absentee ballots. We refer to it as the absentee ballot chase. It was pointed out to me on more than one occasion that he would have won, and won quicker and cheaper and more quickly, and been seated more quickly if I had never come up with this idea. But we did. We thought it was important that everyone who cast a lawful vote have it counted. So we chased these rejected absentee ballots to the end, and that became the big issue in the dispute. And here, in a nutshell, like Roe versus Alabama, is what was at issue. The Coleman lawyers were able to point to a certain number of instances where County A had accepted a ballot, okay, had accepted an absentee ballot that did not meet all of the requirements of Minnesota law. And their point was, well, if County A accepted that ballot, don't equal protection principles, doesn't Bush versus Gore require us to accept that in County B, C, D, and E? Or, for that matter, for other ballots in County A that look like that one. And it poses the same dilemma for sort of society, for democracy, as Roe versus Alabama did, which is on the one hand, you have people who you're sitting there thinking, well, okay, maybe they didn't do everything right. But I mean, they are Minnesotans and they did cast the ballot, so should we count it? So on the one hand, you have an effort, you have a desire to enfranchise voters. On the other hand, you have the fact that there are rules set in advance of the election, and people know what those rules are, and you want to incentivize people following those sets of rules. Further undermining the Coleman argument was the fact that it can't be a principle of equal protection law that anytime a county does something wrong once, it has to repeat it. Because under that theory, if you let one felon vote in one place in Minnesota, felons are not allowed to vote in Minnesota, as in many places. If you let one felon vote in one place in Minnesota, then every other county has to allow all felons to vote. If one person erroneously votes twice in one place in Minnesota, then everybody has to be allowed to vote twice, otherwise you have an equal protection violation. So it logically doesn't hold together that simply because in County A something was allowed to happen, it has to be allowed in County B. So that is the fundamental legal issue that went up to the state Supreme Court in Coleman versus Franken, is how do you take this Bush versus Gore principle of equal treatment of all voters? How do you take this due process principle that there are rules that people have to follow, and how do you square those two? How do you take those two things and make them work together? Now, along the way, how does this all get done? And this part is less obvious from reading the cases. If you look back to recounts prior to Bush versus Gore, they were relatively calm and political affairs. To the extent there was a contest and there was a recount and a contest in the mid '80s for an Indiana House seat, in which the state had certified one person the winner, and then I think the state then certified another person the winner. There was confusion as to who won it, and the Democratic House did its own recount and determined that the Democrat won and seated the Democrat. The Republicans in the House said that this was an example of the political process run amok, that you shouldn't be able to do that. But as I pointed out when I mentioned the Louisiana contest in 1996, that was not that unusual. It was not uncommon. It has not been uncommon over the years for each house to engage its own recounts and decide its own contests. 2000 marks this dividing point because you now have all of this need for lawyers. So in Minnesota in 2008, we had hundreds and hundreds, and by hundreds and hundreds, I mean hundreds and hundreds of lawyers. In fact, at times we had more than 1,000 lawyers during the actual recount itself at various counting locations, tracking data and reporting it back so that we could have a good picture, a good understanding of what was going on. The Minnesota recount took 7 months, as I mentioned. It took 4 trips to the state Supreme Court, and it wound up costing each side over $10 million. I think the total cost of the recount between Coleman and Franken was north of $20 million, and I think closer to $25 million, which dwarfs by magnitudes of more than tenfold, I think, or close to that at least, what the two sides spent in 2000 in Bush versus Gore. So what you have had, the consequence of Bush versus Gore in establishing these legal principles that we now view as sort of the framework upon which elections should be decided, is to push more and more of these towards court. And with that come all of the ancillary benefits and consequences of these being resolved in court. Now, I wanted to just mention one last case and then take any questions that people had. Right now, as we speak, there is a very, very significant post-election case that is being considered that comes out of Hamilton County, Ohio. It's Hunter versus Hamilton County Board of Elections, and this is one of these cases that means where the underlying facts means absolutely nothing, but the legal conclusion might mean quite a bit. There was an election for, I believe, a judicial, for a juvenile court judgeship in Hamilton County, Ohio. And in many states, including in Ohio, if you show up at the polls and you are not in the right place or you're not otherwise on the rolls, you have a right to vote a provisional ballot. Okay, the idea is that they want to keep the lines moving on election day, so you get to vote provisionally, and then after the election, they sort through whether or not your ballot should count or should not count. And in this instance, two things seem to have gone wrong. Number one, some number of voters showed up at the actual, which you're allowed to, showed up at the county offices and essentially voted absentee or voted provisional in person. And they were, in some instances, sent to the wrong desk and voted in the wrong precinct. Now, by voting in the wrong precinct, I mean literally like you were told to go to the person sitting in that chair and you were supposed to go to the person sitting in that chair. So it's not like you were in the wrong building, you were just literally were sent to the wrong table or the wrong chair. Strangely enough, on election day, the same thing happened in precincts. There are places in this country, and some of you may have voted in this, where you'll have multiple precincts in the same physical location. So you might have a local high school that will have precinct 31 and precinct 32 for local elections. And when you go in, you tell them where you live, and you show them ID, or if it's a non-ID, you give them your address, and they tell you which precinct you're in, and then you get in line for that precinct. Well, it turns out that at a polling location that had multiple precincts, some number of people wound up in the wrong line and voted provisional there. So you had some people in the wrong line voting provisional at the headquarters, the county headquarters, some number of people showing up in the wrong line at a precinct. The county decided, well, geez, we sent them to the wrong line, so we should count their vote, right? The precinct people said, it's very clear in the law. If you vote in the wrong precinct, it is, by the way, in Ohio, very clear in the law. If you vote in the wrong precinct, your vote doesn't count. So two voters, both voting in the wrong precinct, one because of election judge error at the county, and the other because of election judge error at the precinct, wind up in two different places. The state courts in Ohio say basically life is difficult everywhere, and that's the way it is. A lawsuit gets filed in federal court, and the Sixth Circuit, in a 2-1 decision, says, sorry, state of Ohio courts, we are the arbiter of the federal Constitution, not you, and we think this violates Bush versus Gore because we have two similarly situated voters being treated differently. And the state of Ohio, or the state defendants, I don't know if it's actually the state itself, but the state defendants, the county, is now seeking en banc review from the full Sixth Circuit on this question. So that's kind of the latest iteration of this. What you'll find in this area of the law, like a lot of areas of election law, is that because these cases come up so infrequently, there is oftentimes relatively little precedent to go off of. So the one lesson, or one piece of advice I'd leave you all with, which is true in all areas of the law, but is particularly true in this area, is when you read these opinions, it's really important that you read opinions critically. And there's no probably better piece of advice I can give all of you for when you go into private practice than to not, there is sometimes a tendency when you read judicial opinions, you sort of start at the beginning, which is good, better than starting at the end. You sort of start at the beginning, you read them, and you're like following along, and you're like, yeah, well, that makes sense, and that makes sense, and that makes sense. And oh, yeah, I guess that's right. I guess that's how it had to be. I mean, these opinions tend to be written in a way that don't present questions as close questions. They present questions as easy questions. And so I was thinking about this as I was preparing for today, and let me just close by giving you the following. there was one of the questions that came up in Coleman versus Franken was whether or not you are required to show intentional discrimination in order to prove an equal protection claim. Okay, it's actually been black letter law in some circles, in certain Supreme Court decisions, that in order to prove, you cannot prove disparate impact. You have to actually prove intentional discrimination to make an equal protection claim. Now, interestingly, there's no allegation of intentional discrimination, by the way, in Bush versus Gore. But nevertheless, there is case law that says that you need to prove that. If you read the final decision that I cited to you in Coleman versus Franken, the Supreme Court of Minnesota takes it as an article of faith that that is true. They just say it. They say, and of course, you have to prove intentional discrimination to make an equal protection claim. There is no equal protection claim absent proof of intentional discrimination. The appellate court in Ohio, or I should say the Sixth Circuit, you read their opinion, and they come to a complete opposite conclusion. They say now the parties say that they have to prove intentional discrimination, and of course that's not true. And then they cite Bush versus Gore. And what's interesting is that when you read those two opinions, unless you hold them up to one another, both of them, the judges or the justices writing these opinions, treat this as self-evidently the case. And they deal with them with simply citations. One simply with a citation to Bush versus Gore, one with simply a citation to, I believe it was Snowden v. Hughes, which had been an earlier case that said you needed to prove intentional discrimination. And there's little effort by the court to try to reconcile these two provisions with one another. I think there is, by the way, a way to reconcile them. But the courts sort of glide through that and don't bother. So my advice to you is that as you go through law school and then into your careers and you read cases, read them critically, because very often the judges are glossing over what are sometimes the really hard issues. And it's why I distinguish between the cases and the disputes, because the disputes are usually a lot messier. By the time George Bush's lawyers walk into the Supreme Court in 2000 to argue this case, there's a lot of water under that bridge. I won't say it was preordained or that it was a foregone conclusion or the lawyering and oral argument didn't matter. Maybe it did, maybe it didn't. But I know this. I know that by the time they'd walked in there, the Florida State Supreme Court had ruled several times and had been criticized in earlier U.S. Supreme Court rulings. There had been action on the part of the local election officials, both at Palm Beach County level and by Katherine Harris, the Secretary of State. There was a macro political environment around this having to do with the timing of the decision and whether or not the so-called safe harbor would be met for choosing the next president. And it's oftentimes not captured in these opinions, all of those other things going on. In Coleman versus Franken, by the time we got to the state Supreme Court, we had been through a hand recount of 2.9 million ballots, a state canvassing board hearing reviewing about 1,500 of them, a 7-week-long trial. We had been to the state Supreme Court 4 times. It doesn't mean that I was foreordained to win. I think I had the better of the legal argument. And by the way, the state of Minnesota had been without a senator at that point for 6 months. I won that. Al Franken won that election because he got more votes, and we won that case, I think, because we were on the right side of the law. But you can't read those opinions without understanding all of those dynamics. And like I said, if there's one thing I would offer you is to be critical as you read through these opinions, because very oftentimes that flavor doesn't come through in the way in which courts will sometimes treat various precedent. I'll take any questions people have. Yep.
Got kind of more practical issue. I would say that one of the results of Bush v. Gore also is the extent to which the public at large has become informed about these recount fights because they've become so political, and I think the media has picked up on them a lot more than before that case. And I'm wondering now, in today's climate, I mean, I think about Joe Miller and Lisa Murkowski, where I don't think Joe Miller had necessarily had unconvincing arguments, but in the aftermath, a lot of what many people think kind of sunk his post-election efforts was kind of the sore loser syndrome in the media, and then individuals within his own party basically telling him to, quiet down and just kind of accept the fact that he didn't get as much votes. So to the extent that that's become more of an issue after Bush v. Gore, how does that factor in now to kind of your post-election efforts, particularly when you think that you've got the votes, and that you think with just enough work you're going to be able to prove that out?
Yeah, so a couple of things. First of all, I query whether that result would have been the same, not the legal result, but the political result if it had been a Democrat versus a Republican, right? I mean, part of what was driving that, I think, was that you essentially had two Republicans, and therefore some of the natural partisan fervor that might have existed or support, I think, evaporated for Miller much earlier because the Republicans weren't going to lose a seat in the Senate either way. I do think, though, that there is an interesting, it's funny, I mentioned that last Friday I was at Ohio State University. It was a symposium on what alternative dispute resolutions could offer post-election disputes. And it was interesting because most of the academics in the room came to the conclusion that the answer was probably nothing, which led me to think, well, then why are we holding this symposium? But be that as it may, the most criticized decision from the Franken recount. So we identified that there were these rejected absentee ballots that shouldn't have been rejected, and I argued that to the counties and to the state, you can't not count someone's ballot when you know that the state made a mistake. Okay, if someone cast a lawful vote and it was not counted due to state action, error by state actors, it has to be counted. And ultimately, I convinced the counties and the state canvassing board that there would be a mechanism to count those ballots. Coleman's legal team then filed a lawsuit that went to the state Supreme Court saying that you cannot, under state law, count a vote that was not part of the original count in a recount, because after all, recount means you can't recount something that wasn't counted the first time. So if it wasn't counted the first time, even if it was erroneously not counted the first time, it can't be counted. That goes to the state Supreme Court. And it's a pretty, if you think about it, it's a pretty stark choice. You either have the idea that you can't recount something that hasn't been counted, or you have to give every vote equal weight and let them all be counted. The state Supreme Court issued a ruling that was 3-2 that said that it was going to order the counties, get this, the counties and lawyers for each side, under penalty of Rule 11. All of you have taken civil procedure. The one rule you'll remember your whole career is Rule 11. Couldn't tell you what Rule 25 says. I could tell you what Rule 11 says. Okay? So under penalty of Rule 11, the parties' lawyers and the counties were to meet and negotiate in good faith to determine which ballots had been erroneously rejected and should be counted. This was decried by the minority on the court, by the press, and by most of the academic legal community in Minnesota as a terrible, terrible thing. Because here it is, you had turned people's right to vote over to partisans that would be making partisan decisions. And how could the right to vote hinge on the agreement of Democrats and Republicans? And this would be disenfranchising, for example, to third-party candidates who wouldn't have a representative in the room. Okay. In some ways, and I said this last Friday in Ohio State, in some ways that was just the court ordering ADR. Right? It was saying, let's not make a judicial decision here. Let's force the parties into some almost mediation with court sanctions hanging over their head into some sort of mediation. And what was interesting is that it was that decision was widely seen, and to this day is widely seen as the worst decision and the least legitimate, quote unquote, decision of the process. And it leads me to wonder if the psychology of the country just hasn't changed, that we now actually prefer that the courts be the ones who make these decisions, that they are viewed as a more legitimate decider of this, that my suggestion that the Senate might decide something was viewed as bringing it to was seen as a provocative suggestion that would be inappropriate. The idea that the parties would sit down was seen as giving the parties the right to control people's right to vote, and that really it is that it is really the courts that are the legitimizing institution in these instances. And I wonder if that is a consequence of 2000.
Along those same lines, what about why do you think the court took Bush v. Gore, why do you not think they punted on any of these recounts as political questions and under their various doctrines to just not take them? And do you think it could potentially, in the long term, undermine the court's legitimizing function if it becomes too bound up in these political processes?
Well, so to your second point, I think that that's the bridge that may just have been crossed. I mean, we may have crossed that bridge, and there just may not be a way back over that because, you know, I'm not sure that at this point the public would view a non-judicial resolution, a non-judicial resolver, as more legitimate than the courts are. So the courts may be stuck with it, having taken Bush versus Gore. Why did they take it? Who knows? You know, this is where you get into, and I have avoided wading into the, was it for this reason, was it for that reason? I suspect that if you ask the majority, they would say they took it because it involved a federal election, it involved the U.S. presidency, and it involved the right to vote, and those are all federal issues.
A Minnesota judge came and spoke last year and said that they were actually very, very proud of the way that they handled the election, that they did it very deliberately, they took a long time. Comparing the two processes, I know they were very different of how the Florida courts did it and how the Minnesota courts did it. Do you have any insight into which time frame is more appropriate?
Yeah, so the one case I lost in Minnesota, and it's a good thing Al Franken won in the end because otherwise people would remember me for this. Because I lost, and I lost a doozy. I mean, I lost unanimously. I lost unanimously quickly. I lost unanimously in an opinion that had nothing good to say about my argument. And all of that was on top of an oral argument in which I got eviscerated by all of the justices. It was a uniting experience for the conservative and liberal wing of the Minnesota Supreme Court. They could all agree that the argument I was standing before them making, they hated. And my argument went as follows, at the risk of making it again. My argument went as follows. The Minnesota statute that provides that an election certificate does not issue to the end of a contest violates the federal constitution because the U.S. Constitution provides that every state shall, not may, but shall have 2 U.S. senators and prescribes the date that their term begins as January 2nd or January 3rd. January 2nd? I should know this, by the way. And that Minnesota could not change that to have 1 senator while it decides an election dispute in the interim. So my own view was and remains that the Minnesota process is probably too long. I mean, I would, if it were up to me, states would have from November, from the first Tuesday, the Tuesday following first Monday in November until, till the swearing in of the new Congress, and that's the state period. And after that, it would go to the House or the Senate to decide. But they don't get to have a process that runs longer than that. There is a tension between states that want to get it absolutely right and states that want to get it done. Minnesota is a state that absolutely wants to get it absolutely right. I mean, it became clear to me as that went on that there was never going to be a point at which Minnesota was going to say, let's just be done with it. They were always going to want to make sure that it was absolutely right. So, the reason why I think from a legitimacy standpoint, it benefits Franken, because from a legitimacy standpoint, by the time Al Franken got seated, Norm Coleman had made his equal protection claims and his other claims before a state canvassing board which included 4 judges and the Secretary of State, including, by the way, the Chief Justice of the State Supreme Court, Eric Magnuson. Before a 3-judge district court panel in a 7-week trial, those 3 judges, one was a Democratic appointee, one was a Republican appointee, and one was a Ventura appointee. And then to the state Supreme Court, the majority of which I believe were Republican appointees. And during the course of that, he never garnered a single vote from a single judge at any level for his equal protection claim. So that by the time you got to the end, you had a unanimous Supreme Court upholding a unanimous trial court, which upheld the decisions of the state canvassing board. So, I think in the end, that's what you get for a state process that gets everything right. There are other states that don't do that. They set time deadlines and then they do the best they can. I'll tell this very, very short anecdote, and then if there are any other questions. I did a small stint back in Minnesota, strangely enough, this past winter. Marc Dayton, who had been in the U.S. Senate and was a client of mine when he was in the Senate, ran for governor, won a close governor's race by about 8,000 votes. There was a recount. I went out to Minnesota for Marc Dayton for his gubernatorial recount in November and December of 2010. It ended relatively quickly because the margin was nearly 9,000 votes, and it was clear that Emmer, who had run against him, was not going to win. So we had gotten 97% of the way through the recount. They had done all the counting and they had done some of the reconciling, but not all of the last reconciliation. Okay, I won't bore you with the process of reconciliation, but suffice to say, they had done most but not all of it. And it was clear that both candidates had gained votes and that Dayton had gained more votes. Okay, so Dayton's lead went from like 8,400 to 8,700. Emmer concedes. Okay, the day we are there to do the final reconciliation, Emmer concedes. His lawyers submit a notice of withdrawal saying we're done. We've conceded, we withdraw our request for the recount. And we then had a hearing over the following question. On the certificate of election, should it list the original pre-recounted totals? Should it list the partially reconciled numbers? Or should the state canvassing board not allow Emmer to withdraw, force the final reconciliation, and put their number there? God love Minnesota. A lot of states, they wouldn't care, right? The answer is you won by 8,000 votes and the other side conceded. Who cares? In Minnesota, this was an honest, you had justices of the Supreme Court opining, you had district court judges, you had Marc Ritchie, the Secretary of State. This is a state that cared a lot about those kinds of processes. How important is it that it's not just who won, but exactly what was the margin was something that they debated. They ultimately, by the way, all decided, once I took the position that I was with Emmer's lawyer that we could just go back to the original numbers, it kind of took the air out of the balloon because now they were all standing with no litigant before them arguing anything other than let's go back to the old numbers. But that's something that is going to vary state by state. And my own views is I think there should be process. I don't think you need as much process as there is under Minnesota law.
All right. So let us think very well.
Produced by Duke University. Online at duke.edu.